Okay.
Okay. Mr. Jonathan Emore, thank you so much for being here today.
You're welcome.
I know
You're
you've done probably thousands of these interviews. You haven't ran for office.
Yes.
So your face is so beloved. And I know that you have
Well,
so
I
many
don't know
people.
about that.
Oh, yes. Oh, my goodness. For those of us in this fight, absolutely.
Oh, sure.
So again, thank you. Thank you for so much. Thank you so much for what you've been doing.
You bet. You're welcome.
And you have, now for those that don't know you, can you just give like a high level snapshot of how you
Sure.
got here, your background?
So I've been a constitutional lawyer for the last 38 years, largely in Washington, D.C. area. Northern Virginia is where I have my office. And I've sued the government over and over again in that 38 years. I have the record for defeating the Food and Drug Administration in federal court, which is 13 times.
Wow.
Just actually a week ago, I defeated them again.
Wow.
And 8 times on constitutional grounds. So
Wow.
I have the dubious distinction, or maybe I like the distinction, but others would say it's dubious. They call me the FDA Dragon Slayer.
I like that.
I like that too.
I
when
like
saw it,
that.
yeah.
That's fantastic.
Yep.
Now, I know your time is limited, and I sure appreciate you being here with us. I know you've known John Hewlett for a long time.
Yes.
Many people on the team here,
Yep.
and they're all
Tremendous.
great fans.
They're
Robert
tremendous
Scott
people.
Bell, we all love and adore you, and we really appreciate everything you're doing. It's not just for us, I've been in the nutritional industry for 37 years, so I have been in many of those fights trying to protect our right to be healthy. And I look at it that way.
Yeah.
And yes, come against the ones that aren't doing their job, for the products and the companies that are putting, arsenic in their products, so to speak. But you've been in the fight for the good ones and for our freedoms. Can you share a little bit about that? I know your big case
Sure.
was the Chevron as well.
So many years ago, I guess the hallmark victory that I had over the FDA was Pearson versus Shalala. And that was a decision in which the FDA had censored a series of health claims, omega-3 fatty acids and coronary
What year
heart
was
disease.
this?
1999.
Amazing.
And at that time, the only way you could get a health claim was if you established what was called significant scientific agreement, which was a standard created by FDA that was virtually impossible to meet. They required there to be no inconclusive evidence, 100% supportive evidence. And even then they would question the evidence. So it was an impossible standard to meet. So they shut down what Congress intended to have, which was to allow the public to get access to nutrient disease information that was truthful. They created a standard of review that was so high, it was impossible to meet it. So I sued them on behalf of Dirk Pearson, Sandy Shaw, and a number of other parties on First Amendment grounds, saying that they could not disallow truthful information from reaching the market through the use of a scientific standard that was impossible to meet.
Wow.
And I argued that claim qualification was the constitutional remedy for the agency, that they couldn't prefer suppression of information over dissemination. They had to allow the information, if it was truthful, into the market. And if there was some inconclusiveness related to it, then they were obliged to use a qualification to say the scientific evidence in support of the claim is inconclusive. So the principal claims involved were omega-3 fatty acids and coronary heart disease, folic acid, and reduction in the risk of neural tube defect births, fiber and colorectal cancer, and antioxidant vitamins and reduction in the risk of cancer. We won all of those in that case. But the most significant of them was the folic acid decision, because people may not know this, but folic acid, just a small amount, 800 micrograms of folic acid taken by women of childbearing age can reduce their risk of having a neural tube defect birth, spina bifida, anencephaly, brain outside the skull at birth, spinal cord outside the spinal column at
So
birth.
was that the year? I mean, then it became normal for doctors to recommend.
That's right. So before that
folic
time,
acid.
it was prohibited by the FDA until that decision.
Oh,
And
my.
what in the case of supplements containing folic acid. There were, the court agreed there were an estimated 2,800 neural tube defect births a year, preventable ones. and there were countless NTD-related abortions. So
Wow.
this decision then brought the number of neural tube defect births way down. After this decision, roughly a year
Amazing.
later, people began taking more folic acid and folic acid supplements, and they were reducing the incidence. And then also NTD-related abortions almost disappeared. So there are tens of thousands of babies who are healthy, born today because of folic acid that they didn't know about until this
That's
decision allowed it
amazing.
into the market. But that's one set of claims. We've won numerous other claims against the agency, selenium and cancer risk reduction, numerous other ones. But lately, there's been a change by the Supreme Court in the law that will open up the market potentially to much more health information. And the FDA has never abided by this Pearson decision. They've never honored it. They've always tried to undermine it in every step of the way. We've been able to fight them over and over again, beat them again and again, get more information out. But still,
But you
there
have
is
to keep going
enormous,
back, going
there's
back,
an
yeah.
enormous amount of nutrient disease information that is kept from the public by the FDA.
And then they claim it disinformation.
Yeah, well, they're masters of disinformation.
They are. Yes.
They were telling people, what we now know in retrospect, that had that folic acid information been out there when it was discovered to have a reduction effect, we would have had 10 years at least of substantially lower levels of NTD births. So we've had thousands of babies born with neural tube defect births. Hundreds and hundreds of them died. And those that survived have had lifelong medical difficulties and costs that are astronomical that the families have to bear that insurance just simply won't cover.
And that must have hit hard because you're a dad.
Yeah,
And
that's
a family. You have a family. And so I'm sure all that became very personal.
Yes, the case we just won last week against the FDA will save thousands of lives too.
Talk about that.
And
That's exciting.
It's called Bonumose versus FDA. Bonumose is a company in Charlottesville, Virginia that makes a monosaccharide, a sugar that is remarkable in its processing. It has 1/3 the calories of conventional sugar, and it has 90% of the sweetness of conventional sugar, but it has none of the deleterious effects of conventional sugar. It doesn't raise blood glucose levels at all, and it produces beneficial bacteria in the gut because it functions in the body like a soluble fiber. So this product can also be used in all sort of baked goods, all sort of beverages. And when it is ultimately, the decision lays the foundation for this, when it's ultimately in the market, all those foods that people eat that have had that high quantity of sugar in it will suddenly be replaced by something with 1/3 the sugar.
Wow.
And with none of the deleterious effects.
Wow.
And that means diabetics will live longer. That means people with cardiovascular disease will live longer. That means lower incidence of cancer. That means that a lot of people with
hyperactivity
and gut-related issues and so on, all of that is going to start disappearing from the market and people will live longer. So this is a major
that is
victory.
Major. But isn't it amazing how the enemy tries to keep good things from us to be able to stay healthy? Yeah. It's crazy.
It's all about protecting the drug industry from competition. That's what it's about.
Well, congratulations.
Well, thank you.
That's major.
Yeah.
You know, having children myself and grandbaby, and you think about, you know, their future and their choices that they have.
Right.
Because other than some of the other, you know, additives that we add to, you know, make things flavorable, they all have these horrific side effects. And they can be neurodamaging and all the rest. So again, that's congratulations. That's amazing.
Thank you. Yeah.
And now with the Chevron.
Well, so the Supreme Court had a decision called Loper Bright Enterprises. And in that decision, they overturned a prior decision that was reached in the 80s called Chevron. And Chevron stood for the proposition that if an agency, if an enabling statute is called, if a statute that an agency relies on was ambiguous in some way or was silent as to a specific problem the agency was confronting, that the court would defer to the agency's judgment as to what the statute meant.
Okay.
And this created a environment of deference to agency power and judgment that turned over the judicial decision-making authority of the independent Article III courts that the founding fathers created
Wow.
to this really essentially unconstitutional universe of regulatory agencies, over 250 regulatory agencies that have combined legislative, executive, and judicial power and are largely unchecked by the courts, the Congress, and the American people.
That's crazy.
And this is the court part of it, where they were just not reviewing what agencies would do. And what agencies would do was just horrendous. So they were running roughshod over the market,
Right.
taking away products people liked, destroying businesses. And the FDA was a big culprit in all of this. And people don't realize that when you're in an administrative agency action, when you're the defendant, you're a business or you're a person who's being charged with something by an agency, you have virtually no constitutional rights protections.
That's
They
right.
function outside of the Constitution's
Right.
parameters. It shouldn't be that way, but that's how it's grown up to be, so that you're guilty until you prove yourself
Mhm.
innocent.
I remember when I would have to teach companies to DSHEA training and try some of those rulings that came. The Dietary Supplement Act they were so crazy
Mhm.
that you try to get these companies to adhere to that, and it literally they couldn't. It
Yeah.
was really crazy.
Yeah, in an administrative, and I've done many of these hearings, in an administrative hearing context, like at the Federal Trade Commission, you have no right to confront your accuser. So you don't know who's brought these charges or what their motivation
right.
was. The judge is also effectively the prosecutor, because ultimately, the ultimate judge is the prosecutor. The agency brings the charges against you, and the agency ultimately reviews what the administrative law judge does. What the administrative law judge does is just a recommendation to the agency, which is the final judge in the agency. So when the party prosecuting you is also the judge, you can have no justice in that. You have no discovery in these cases against the government, virtually none. The government has unlimited discovery. In fact, they have what's called a general warrant power. General warrants are unconstitutional under the Fourth Amendment. If you're in a court, you could never use that. And every aspect of it, they can change the nature of the charges against you all the way up to the time of decision. And you can have no notice of the change in charges. And they frequently do change the charges. That's impossible in court because of the Federal Rules of Civil Procedure and judicial precedent. You can't do that. The Constitution forbids it under due process.
So this is what is interesting. I'm listening to you because I've been in this field for so many years.
Yeah.
But the average person starting out there, they have a product, right?
Right.
Garden Miracle. We love it. It's like our mainstay, right? The average company starting out there, and I've been with many of them, they start out with eyes bright.
Yep.
They have this beautiful, product that they're going to bring to market, change lives, and they get bumping along and put all their monies into it. And I've seen this happen, and it's so demonic. And you grieve for them because
you would think that
they don't know anything that you're talking about.
Right. And you would think that you would have to do something that would hurt someone in order to be subject to criminal prosecution.
Right.
But that's not the case. If you sell prune juice and you put on the prune juice label, this cures chronic constipation, that's true. But you've just committed a crime. You've just put into the marketplace a drug. FDA interprets that as transforming the prune juice into a drug.
That's right.
This is the nature of this beast. It's been designed from the start. The whole statutory scheme has been designed to protect the drug industry from competition, to prevent companies that sell food products and elements of food products from making therapeutic claims, because even if those claims are true, they would create a competitive threat to the pharmaceutical industry, which controls the FDA. So it's a sad tale of how we have really destroyed people's lives, literally taken lives. I mentioned the folic acid case. There are numerous cases in which the government, the omega-3 context, when I won that case, before I did, the evidence was before the Office of Management and Budget. And they were looking at it because there was significant proof that there were some 100,000 sudden death heart attacks each year that could be prevented by just taking omega-3 fatty acids. And they reached that conclusion independently, reviewing the evidence that FDA had before it. And they issued a prompt letter, which is highly unusual, and based on our evidence, to the FDA that asked the commissioner to act promptly on our petition and let the claim into the marketplace. And FDA then took another year and a half before it was forced by judicial decisions against it to allow the information in the market. This is an anti-competitive regime. It protects the drug industry from competition. Right. It will do anything to do that.
Anything perceived as a threat.
Yeah, and we have Dr. David Graham, who's the associate director of the FDA Office of Drug Safety many years ago, and he testified as a whistleblower before Senator Grassley's Finance Committee, and he explained in detail how unsafe drugs were being allowed into the marketplace because the industry controlled the drug approval process at FDA. And there are numerous examples. Vioxx is one great example. Here you have a painkiller.
Yes.
It's supposedly a super painkiller.
Yes.
It's being dispensed, approved by FDA, dispensed all over the United States, virtually every hospital, given out like candy to people who had disease, who had surgeries. And yet this thing substantially increased the risk of heart problems, heart attack, stroke.
Yes.
And the evidence was overwhelming that it did. Well, at the time, the FDA commissioner was asked by the medical reviewers who had authorized the product to be put in the market to either put a black box warning on it or do something to get it off the market, because all these adverse event reports were pouring in. And they had a direct dose-response relationship between the dose of Vioxx and the risk of heart attack and stroke. So the FDA commissioner said, I think that this is a safe drug. I'm not going to yield to your recommendations. In fact, I'm so confident in it, I'm approving it for use in pediatric rheumatoid arthritis patients. So against this mountain of evidence of heart toxicity, he approved it for use in kids. And 2 weeks later, Merck withdrew it itself from the market under an avalanche of products liability suits. And the evidence was overwhelming. But what happened to that FDA commissioner? When he left the FDA, he went to work for a place called Policy Directions, Inc., a lobbying firm. And what was one of the major clients of that firm? Merck, the maker of Vioxx. But we see this a lot. This is the corruption that is inherent.
I was working in an orthopedic center at the time when Vioxx was released. And if you could have seen the drug reps coming around and acting like it was holy grail, right? Yeah. But we had one orthopedic surgeon at that time that really did a deep dive. And he said, I'm not going to recommend this to my patients. He got a lot of flack from that because, the drug and the doctors are related.
Oh, right? You bet.
And how much they prescribe, they can all see. All the drug reps could see how many times he prescribed it. So it goes much deeper. And so I can't imagine what your daily fight is like.
Well,
congratulations
thank you
for everything you're doing.
Thank you.
And I pray for your strength and energy. And,
thank you very much.
We all are depending upon you. Truly.
Well, it's a noble fight. It has to be done. And, I'm driven by my love of the founding fathers, the Constitution, and the ideological origins of the Constitution. I believe in freedom. I believe in individual liberty. And we know just how precious that is right now because it's hanging on by a thread. Our Constitution is really barely in existence.
Let me ask you a question.
In the practice of the government.
How many people actually do you think actually know what the Constitution is? That's the frightening
That's
thing.
a sad reality, isn't it?
Our kids and our children and our grandchildren, are they going to really be taught what our country was built on, the Constitution?
They're being taught to hate their own country and to think that the nation is inherently racist. And
I know
this is just simply a falsehood, but it's a malicious falsehood intentionally given to them in order to create Marxists out of kids and turn them against their families, against the free enterprise system, against government,
capitalism,
and against the Constitution.
Yeah.
It's definitely a tragedy that has to be dealt with.
Well, thank you. I know your time is limited, so I appreciate you so much being
You're
here
welcome.
with us. And we sure thank John Hewlett for creating this company and being such a patriot, supporting you on your walk and everything that you were.
He's a great man. I know him
He
personally, and
is.
I know just how great he is. He's
Yes.
a hardworking, honest, decent human being
Hmm.
who's very, very intelligent. He is
Yes.
a wizard, really, when
He's
it comes to
gifted.
details of.
He's really
I
gifted.
listened to him one time. I can't divulge the context, but he spoke persuasively to a person, and I thought, my goodness, I've heard of arguments from some of the best lawyers in the country in court,
Right?
and I thought
Hmm.
his skill and persuasion, his
Yes.
ability to
Yes.
communicate and persuade is exceptional. He's quite an
Yes.
intelligent
And
man.
his knowledge of the Constitution,
Yep.
his knowledge of our, of what our founding fathers stood for.
Yep.
So that truly, we back him and we love the product that he created. And thank you
Yep.
so much for standing in the gap
You
for
bet.
all of us that are trying
He's
to
a man of
promote
great
good
faith
things. Yes.
and great commitment to our
Yes.
country.
Yes.
And I think he's deeply interested in helping people.
Oh, yes.
He's a person of great charity.
Mm-hmm. Yes.
Yeah,
He
the pure
really
love of
is.
Christ.
To get up every day and say, you know what? If I can save one more heart of mankind, right? That's
Yeah.
his saying. So
He's a
thank you
good
for
man.
standing in the gap for him and for all the rest of
You
us
bet.
consumers that are trying to stay healthy. Bottom line, we're just trying to stay healthy.
Yeah.
We're trying to do what God created us to do and do it in a way that we're not sick and feeble. So again, thank you so much, Jonathan.
You're
God
welcome.
bless you.
Thank you.